All right, let's proceed.
Good morning again, Your Honor. Ron DeRosa on behalf of the Commonwealth. In this matter, although the Superior Court brief addressed the stay issue, if the panel has any further questions, or if the court has any further questions with regard to the stay, I think I've addressed that fully. Unless the court has any further questions, obviously I will answer them as they come up. But the two issues that the single justice has reported to the court in this case are whether, number one, whether the court should answer the question in the first place, and number two, whether in fact the special magistrate has the authority it purports to exercise by participating in the plea colloquy proceeding. As to the first question, I would suggest that the court should answer the question in light of, again, repeating myself, the sort of uncertainty with regard to special magistrates, the dearth of case law, the lack of the appointment of their position beforehand, and the possibility that were these pleas not, were the special magistrate's authority to conduct the pleas challenged later on, that would just, we would sort of be in the situation all over again. So
let me ask you on that. I appreciate your concern that these motions arguably could be challenged later on, but if you get the ruling that you ask us, well, if you get a ruling that says it is appropriate for the special magistrate to be doing these pleas in the fashion that they're doing them, do you then agree to have the special magistrate hear them? Because right now you have a choice. Will it change the conduct? I mean, if we say that the fear which you are concerned about is not a real fear because we've addressed it, does that mean that you then say, okay, we will no longer object to a special magistrate doing these pleas?
yes, Your Honor. Our concern with this was particularly that in light of the language of the case law, in light of the lack of express language in the order of assignment, empowering, certainly these pleas cannot be argued to be post-conviction motions.
So the yes that you just gave is yes, you would
not object. That's correct, Your Honor. And as to whether or not the question needs to be answered, the Superior Court points out in its brief that the procedures or the pleas that have gone forth, they've required both parties' consent before they go forth. That's nowhere in the rule. That's nowhere in the order of assignment. In fact, the Superior Court in its brief cites to the affidavit of its general counsel that obviously is not binding authority upon the court. So this court should answer the question because theoretically, although it hasn't happened in Essex County yet, a special magistrate could conduct a partial part of the plea colloquy and then send it over for a judge for the adoption of the findings he or she makes during that.
So it was kind of off the record that in Essex County each time when the district attorney objected, it didn't go forward.
No, I would suggest that it's in the record that the Commonwealth, that the Essex
Right, but it's
district,
not part of the rule.
But it's not part the Superior Court's assertion that both parties' consent is required to proceed under the procedure that's set forth by the Superior Court simply comes from the affidavit of its general counsel. It's not. But
I guess that what I'm asking you is, as I understand it, as a practical matter, in this case, at least I think I read in the affidavit that you filed from Mr. Shea, that when this was proposed, the defendant consented. You said no, and that was the end of it. Yes, that is the case. So, but there's nothing in the rule or the order requiring the special magistrate to acquiesce to that objection. In light of that, we're asking this court, and I would suggest that it is a plausible argument under Rule 47 in light of the comments, and again in light of the fact that nothing in the rule requires special magistrates to be attorneys, or it states a preference for retired judges and an intention that they be attorneys. Nothing in the rule or the order of assignment mandates it, and I certainly respect Chief Justice Rouse's order appointing retired judges as special magistrates, but simply nothing in the rule or nothing in the comments to the rule suggests that that's required. The rule also suggests that
the authority of the special magistrates in Massachusetts are not as broad as the federal magistrates. Well, federal magistrates are, if you look at the federal law, entitled to conduct plea hearings, but they are so, at least this, I believe the circuits have found, under sort of a catch-all provision of the Federal Magistrates Act. Other states that have allowed magistrates to take plea colloquies have done so by express provisions in either a statute or their constitution. So in those states that we were able to find have been cited in my brief for those that do allow. Some allow them to conduct all pleas, some allow it just for misdemeanors, and some don't allow it at all.
But those are situations in which the plea is actually accepted and sentence is imposed, isn't it?
The other states, I believe, I can't say off the top of, I can't say whether their procedure would be the same, whether there would be proposed findings and rulings or not. But I would just simply point out that it's at least done by a statute setting forth the specific authority to do it, or there's been an interpretation by the court that, in light of the language of the Magistrates Act in particular, that the court isn't able to do it.
Now, is this a matter purely of state law, or is your contention that under federal constitutional law, the special magistrate can't do this?
Well, I would suggest that part of the reason the court should answer the question is because there are concerns. The federal law suggests that because the defendant is required to consent, as he is in Massachusetts, he would waive any sort of objection to it. However, there was a dissent, I believe Justice Scalia and two other justices whose names are escaping me, that didn't answer the question definitely, but certainly left it open that there may be some sort of structural or other constitutional right to have an Article III judge hear or to conduct a plea colloquy. So my reading of the federal case law would be that a defendant would waive it in this case because under the way the rules are currently set up, because he would be assenting to the special magistrate conducting the plea colloquy. But it's certainly, it's not a closed question anyway, whether or not it is.
And what would, if we were to say, or if you were to argue to us as to what would be appropriately constitutional, what would be the contours of the plea colloquy that a special magistrate could do or not do?
I think the way it's set up for essentially to, again, obviously he's not allowed to sentence the individual, but to conduct a plea and make a determination whether or not the defendant is waiving his rights knowing and voluntarily. And then, in essence, send it over to a Superior Court judge for, perhaps a review of the proposed findings and rulings that the court has in the record appendix that the Superior Court has promulgated. Making sure the defendant's fully aware of what's happening when it comes to in front of the Superior Court judge, and that the Superior Court judge would then impose the sentence or essentially the procedure that is set out by the court, I would suggest, would be the constitutional one.
Does the Superior Court judge need to conduct any form of colloquy?
I think there would be a need of a colloquy to assure himself that the defendant understood what happened just before he left in front of the special magistrate, that the special magistrate has made a finding that he's knowing and intelligently, voluntarily waived his rights before the special magistrate, not go through the entire colloquy again, and inform him that he is there before the Superior Court judge simply for the imposition of sentence.
What about the requirements? Do you have a position on the specific provisions in Rule 12 in terms of the guilty plea procedure and what it is that the rule says the judge needs to do?
As to in terms of how much the special magistrate's entitled to do?
Right.
I would think up to the point of the sentence imposition would be what the special magistrate would be entitled to do. A finding that it's knowing and voluntary, were this court to go ahead and adopt that again, I think there's a question in light of the language and the lack of language allowing them to do it in the rule and the comments, but constitutional-wise, I think, and so long as the special magistrate the Superior Court judge has an opportunity to review those findings that the special magistrate has made as a result of the colloquy, and so long as the defendant consents, there would be constitutional authority for him to accept or to proceed in that manner.
How about the acceptance of the plea itself? I mean, I think right now it's a recommendation that the judge accept the plea.
Yes, I think it would have to be.
The judge is the person who accepts the plea.
And, you know, the sort of overall accept, you know, say again.
Because the
there would have
acceptance
to
is the finding of guilt.
Yes, he would, well, you know, based, I think, maybe some sort of statement based upon the findings I have informed me, I accept that you've knowing and intelligently waived your rights. There's a factual basis for the plea, and I will now sentence you, some statement along that line. And unless the panel has any further questions, I'll be happy to rest on my brief. Thank you.
Good morning, Your Honors. Jennifer Grace Miller on behalf of the Superior Court today. May it please the Court. In the face of an unprecedented crisis, the Superior Court had to act. A response was required both because of the sheer number of criminal cases potentially affected and because, as we've already heard several times today, because of the real risk of manifest injustice if the court did nothing. And by manifest injustice, I do mean that there are defendants who continue to be incarcerated when there is some significant doubt about the validity of the underlying convictions. So the Superior Court acted, and in the manner that it acted, it was even-handed, protecting the interests of both the prosecutors and defendants, and it was efficient, addressing the thousands of Hinton Lab cases in a timely way without delaying the thousands of additional cases on the Superior Court's criminal docket. Essentially what the Superior Court did is that it tailored two existing tools to fit the unprecedented circumstances. The first was, of course, the motion to stay, which is usually filed under either Rule 30 or 31, and the second was, of course, the use of the special magistrates, which are permitted under Rule 47. The Superior Court's measured use of these existing tools was entirely appropriate to respond to the crisis, and it was well within the court's existing powers. Now, the district attorney makes two essential objections to the use of these two tools. The first has to do with the motion to stay, which the district attorney asserts should not be a permissible mechanism to address this particular crisis and shouldn't be used by either Superior Court judges or the special magistrates. The argument, as I understand it, is that there is no rule and there is no statute that is applicable in these circumstances. And that, of course, isn't exactly the point. There is no rule, there is no statute that is applicable. There is no mechanism. These defendants are, at the time, in September of 2012, there were 835 affected defendants in jail. Usual, and there's some concern about the validity of their underlying convictions. Of course, the usual way of addressing that is with a motion to new trial. But as has already been discussed today, those new trial motions have been brought, but they can't be brought to conclusion because there is a hold on the various discovery issues while the necessary investigations continue.
When you say affected defendants, how do you define that?
Well, for the purposes, the 835 number, Your Honor?
Yes.
For the 835 number, that was the first group of defendants that the Superior Court focused on. Those were incarcerated defendants where the lead offense was a drug crime and Andy Dukin was the primary or secondary chemist. So that was the first wave, if you will. The folks the Superior Court was most concerned about, the folks who were actually still sitting in jail. And most of those individuals had their motions for new trial, motions for stay. Their first round was actually handled by Superior Court judges. Only a relative handful of the affected defendants in that first group were actually came before the special magistrates. But let me go back. We have a problem. We have these folks sitting in jail, and we have absolutely no mechanism for allowing them an opportunity to say, Your Honor, I should be released pending the resolution of my new trial motion. These circumstances are extraordinary. I should be released. because there is no mechanism, and because there is a real risk of manifest injustice, then of course the Superior Court should be allowed to exercise its inherent powers, as stated by McLaughlin. We're talking about a true reprieve here. We're talking about extraordinary circumstances which hopefully will never repeat themselves. But what the Superior Court gave these individuals was an opportunity to come before a court and say that in my particular circumstances, given my case, given the underlying crime, I should be freed. And that's all it is. It's just an opportunity for the defendants to come forward and for justice to be done.
But I'm quibbling somewhat, but with respect to, it is in my particular case, in my particular circumstances, but because we don't have the discovery, there is a certain, I think, in my particular case, given what we do know, that I am likely affected by, as opposed to
You're
I
right.
definitely am affected by.
Absolutely, Your Honor. It is a partial record. But I do note that not every motion to stay has been granted.
But that's usually on the security question.
Well, I don't know what it's usually on, but not every motion has been granted. So it is an opportunity, albeit on a partial record, and albeit on only the publicly available information as it comes out every couple of months or so, where we learn a little bit more. So it is on a partial record, but here you had an opportunity for the defendants to come forward and say that I should be released in the interest of justice. That is clearly an inherent power of the court, and it's being exercised in a timely and efficient way. The court has already addressed the first group of individuals who are arguably most affected. But of course, this isn't the end of the matter, that first group. The first group consisted of those 835 people, but of course, there were 10,000 cases in the Superior Court where the lead offense was a drug offense, and 10,000 cases where there was some kind of collateral consequence that were still ongoing. So these folks may be out of jail, but they may be serving probation, there may be custody limitations, there are other collateral consequences for these individuals. So while we have gotten through the first onslaught of these cases, and most of them have been heard by Superior Court judges, there's still potentially another onslaught to come. And of course, none of us know what the Inspector General's report is going to say, and so there is the possibility that the Superior Court has to plan for that there may be further cases. Which brings me to the use of the special magistrates. The use of the special magistrates is obviously an effort by the Superior Court to address these cases in a timely way and in, I would say, an unchaotic way. You know who you're going to go before. You know who's going to be handling them. You're developing an expertise in a particular special magistrate. And it was entirely within Rule 47 for these special magistrates to participate in the stay process the way that they did. Rule 47 essentially says that they may make proposed findings and proposed rulings. That is classic magistrate activity. In fact, while the reporter's notes say that these special magistrates are not like federal magistrates and they're not like clerk magistrates, what they say they're most like are special masters appointed by by this particular court. And what do those individuals do?
You mean Rule 53 masters?
Well, both Rule 53 masters in the Superior Court, but also the reporter's notes refers to special masters appointed by this court under 2.13. And what do those individuals do? They have a hearing, they propose findings, and they propose rulings. And they're not effective until, of course, they have been adopted or confirmed by the full court.
Well, are you saying that the special magistrate should not have the authority to make the decision on the motion to stay himself?
What I'm saying is that conservatively applied of Rule 47, where the Superior Court's trying to act in these extraordinary circumstances within particular parameters, that what the system they envisioned was that on motions to stay, the judges would, the special magistrates, would hold a hearing, make proposed findings, and proposed rulings. And then it would be the Raj who issued the ultimate order.
Do you think it's unwise to allow the special magistrates to make the decision itself?
I don't think it was unwise. I don't think it would be unwise. These are, as we've already talked about, retired justices and retired Rajas. So it wouldn't necessarily be unwise. The Superior Court was acting conservatively within the rule, recognizing that these individuals, despite their extensive backgrounds, are not judges, that they are magistrates.
Just out of curiosity, when you were saying that there was the first wave that was handled by Superior Court judges, was objection raised to the authority of the judges to rule on the motions to stay execution of sentence?
I think it depended on where you were.
Okay. I think in Essex County there were.
I think they were in Essex County. So I think it depended on where they were.
Now, if we can turn to the plea colloquy issue.
Of course.
It does sound as if, at least as to that issue, there's some harmony. Do you share Mr. DeRosa's view that it is something that we should decide so that DAs don't need to worry that 2-3 years from now, motions for new trial will be coming, saying that special magistrate did not have the authority to take that plea?
Right. The objection that the Superior Court raised as to the fact that there wasn't an actual controversy in Essex County was really about what Essex County wants, as in its brief, it said that it wants the plea colloquy to be unassailable. And because this particular issue has not been presented on a series of facts, this court's decision will be helpful guidance on the issue, and it may very well resolve the controversy in the sense that the district attorneys will feel more comfortable in engaging in the process and not objecting to proceeding before a special magistrate. But it won't insulate it from all future challenges, because of course those future challenges will be based on a particular record. And the defendants will say, well, I know that the SJC said X, but my situation is Y. So it won't make them unassailable. Nonetheless, the Superior Court obviously welcomes the full court's guidance on the issue, and if only to make the district attorneys more comfortable in engaging in the process so that you can achieve the efficiencies that the Superior Court is hopeful of achieving.
Could you, I'm just not totally clear on what the record shows vis-a-vis other district attorney's office. I certainly know what Essex County's position is, but there's some suggestion that Bristol, Suffolk, and Middlesex are currently following the same view that the Superior Court is without authority. Is that right?
It's not in the record. That is Suffolk County is not in the record.
In the briefs,
right. Essex County is certainly in the record. Suffolk County, we know because there was a representative of Suffolk County that you called upon in the single justice session, and they do share the concern about the special magistrate's role in the plea process. And certainly since the hearing before yourself, Your Honor, no plea colloquies have occurred in Suffolk County. They've all been done by judges. They have been done, however, in Bristol County, and they have been done, although, again, this is not in the record, but offered in the hopes that it's helpful, that it has occurred in Norfolk County. And, in fact,
Bristol County is saying no longer. That's how I read it.
Well, my understanding is that Bristol County consented to these going forward with sort of a soft objection, if you will, Your Honor, that, yes, we're not entirely sure this is right, but we would like this to go forward today in front of you.
All right, no, for those 17, absolutely. I just think going
forward,
yeah,
right.
That's all.
In Norfolk County is where most of the plea colloquies have actually occurred.
And if we do go forward and decide that issue, do you agree with regard to the contours of what would be an appropriate role for a magistrate to play in a plea colloquy?
Right. Again, reading the rule conservatively, this would be absolutely classic special magistrate role. Here they are holding a hearing, they are taking in facts, and they are making proposed findings and rulings to the Raj. And the Raj is the individual who will conduct the adjudicatory, if you will, portions of the process.
And the Raj would be the one who gives the 29D warning and all that.
Right. Exactly right. So when it goes to the Raj will accept the plea based on any additional facts that the Raj may need to convince him or her that the plea is voluntary. They will obviously impose sentence. Those are the critical things.
So how helpful is this? I mean,
It is helpful.
So you're having two hearings instead of one. I don't understand.
Well, Your Honor, I think the idea is that, first of all, while there haven't been a lot of plea colloquies right now, there may very well be a number of plea colloquies after the Inspector General's report comes out and some of these discovery issues are resolved. So you may have a flood of situations where you need someone to be resentenced. The thinking of the Superior Court, and of course, there's some deference to the Superior Court in marshaling its own resources. It believes this would be efficient. But the idea is that, of course, anyone who sat in a Superior Court room and listened to a plea being taken, the longest part of that hearing is the colloquy.
Okay. Thank you, counsel.
Thank you, Your Honor.
All right, thank you.
Very, very